Everything thus far has been about decisions made concerning inmate rights by a court's interpretation of the following rights granted to us by the Constitution. The first rights we will discuss are in the First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. The following slides are a quick summary of how the First Amendment applies to jails. Freedom of speech, including mail and expression. Inmates retain some First Amendment speech rights, including the right to correspond with people outside the facility, e.g., family, lawyers, the media. Mail can be monitored or censored for security reasons, and G. Preventing escape plans, threats, or criminal activity. Legal mail, from attorneys or courts, must be handled with special protections, usually opened in the inmate's presence and not read. Inmate-to-inmate communication may be restricted if it poses a threat to order or security. Turner versus Safley. The Supreme Court held that prison regulations impinging on inmates' constitutional rights are valid if they are reasonably related to legitimate penological interests. Freedom of religion. Inmates have the right to practice their religion, including access to religious texts, diets, services, and clergy. Jails must accommodate religious practices unless doing so would pose an unreasonable threat to safety or operational needs. Denying religious accommodations without valid justification may violate the First Amendment and the Religious Land Use and Institutionalized Persons Act, RLUIPA. Freedom of the press. Inmates can usually receive books, newspapers, and magazines, subject to censorship or security concerns. Jail staff can restrict content considered pornographic, gang-related, or inciting violence. Media interviews with specific inmates are not a guaranteed right under the First Amendment. Freedom of assembly and petition. Inmates have the right to file grievances and lawsuits, including civil rights claims under 42 U.S.C. Sector 1983. Organizing groups or protests within the jail is often restricted for safety reasons. Jail policies cannot punish inmates solely for filing grievances or lawsuits that would be retaliation, which violates the First Amendment. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause. Supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment protects against unreasonable searches and seizures, but like other constitutional rights, it is significantly limited for incarcerated individuals. Courts have consistently ruled that inmates have very limited, if any, expectations of privacy while in custody. Here's a summary of how the Fourth Amendment applies in jails. General rule. Diminished expectation of privacy. Inmates have a greatly reduced right to privacy in their cells, belongings, and even on their person. Courts recognize that jail environments require frequent searches to maintain safety, prevent contraband, and preserve order. Key case: Hudson v. Palmer, 1984. The Supreme Court held that inmates do not have a reasonable expectation of privacy in their prison cell, meaning warrantless and suspicionless searches of cells are constitutional. Cell and property searches. Jail staff can search inmate cells and property without a warrant or probable cause. No consent is needed, and no notice is required. Staff may confiscate contraband or items not permitted under jail rules. Body searches. Pat-downs and strip searches are allowed under specific conditions, particularly when inmates are admitted to the facility, returning from outside work or court, being moved between housing areas. Strip searches must be conducted professionally and in a private setting, by the same sex, to avoid unnecessary humiliation. Body cavity searches require a higher justification and require medical personnel to perform them. Florence versus Board of Chosen Freeholders, 2012. The U.S. Supreme Court held 5-4 that jail officials may strip search all detainees entering the general population of a jail regardless of the offense or suspicion, as long as the search is reasonable and not abusive. Keep in mind that Missouri law has more restrictions on strip searches and body cavity searches. See RSMO 544.193 through 197. Searches of visitors and staff. While inmates have reduced rights, staff and visitors maintain higher Fourth Amendment protections. Searches of staff or visitor belongings or bodies must generally be reasonable and not overly intrusive. Legal mail and personal property. Although legal mail has First Amendment protections, it may be subject to visual inspection, but not read. Inmate personal property can be searched, inventoried, or removed without violating the Fourth Amendment if done under a legitimate operational reason. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. The key element of the Fifth Amendment ID is due process. Inmates have the right to fair procedures whenever they face disciplinary action, e.g., loss of privileges, segregation, transfer to more restrictive housing, loss of good time credits. This doesn't mean a full trial, but inmates are entitled to notice of charges, a hearing, often with a jail disciplinary board, an opportunity to present evidence or witnesses, key case, Wolf v. McDonnell, 1974. Inmates facing serious disciplinary action must receive basic due process, including advance written notice and the ability to present a defense. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. These are the Sixth Amendment protections: right to a speedy trial, right to a public trial, right to an impartial jury, right to be informed of charges, right to confront witnesses, right to compulsory process, calling witnesses, right to assistance of counsel. In summary, the following are some of the major concerns for the jail as it pertains to the Sixth Amendment. Jail staff must ensure inmates receive copies of charging documents, warrants, and court notifications in a timely manner. Getting them to all court proceedings in a timely manner. Allow reasonable access to legal visits. Maintain privacy. No listening to conversations between inmates and attorneys. Avoid interfering with legal mail. Can inspect for contraband but not read it. The Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Eighth Amendment is highly relevant in the jail setting, especially because it protects inmates from cruel and unusual punishment, including excessive use of force, inhumane conditions, and deliberate indifference to serious medical needs. Here's how the Eighth Amendment applies in jails. Key protections. Under the Eighth Amendment, no cruel and unusual punishment, protection from excessive force, humane living conditions, proper medical and mental health care, protection from abuse by staff or other inmates, deliberate indifference. Deliberate indifference. A prison official can be held liable for violating the Eighth Amendment if they are deliberately indifferent to a substantial risk of harm to an inmate. This means they were aware of a significant risk of harm and consciously disregarded it. What it is not. Negligence or poor judgment alone is not enough. Deliberate indifference requires that the staff member was aware of the risk and consciously disregarded it. If a staff member acts reasonably, even if harm still occurs, it is usually not deliberate indifference. Deliberate indifference. What it is not. Negligence or poor judgment alone is not enough. Deliberate indifference requires that the staff member was aware of the risk and consciously disregarded it. If a staff member acts reasonably, even if harm still occurs, it is usually not deliberate indifference. The 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment. The 14th Amendment is the mechanism that applies all the rights we have discussed to state and local governments, jails. Key areas of application: due process, procedural and substantive, equal protection under the law, incorporation of Bill of Rights, protections to states' pretrial detainee rights, conditions of confinement, grievance and discipline procedures. As a jail officer, it's important to remember that while inmates have lost certain freedoms, they haven't lost all their rights. The Constitution still applies behind bars, and that means we have a responsibility to understand and respect the legal protections inmates are entitled to. These rights come mainly from the 1st, 4th, 8th, and 14th Amendments, and they guide how we treat those in our custody. One of the big ones you'll deal with is the 8th Amendment protection from cruel and unusual punishment. That means inmates have to be provided with the basics: decent food, clean living conditions, medical care, and protection from excessive force. If these needs aren't met, it's not just bad practice. It can lead to lawsuits and serious consequences for the facility and individual staff. Inmates also keep some rights under the First Amendment. They're allowed to practice religion and have some level of free speech, like writing letters or receiving visits. That said, we can place reasonable limits if something poses a safety or security risk. For example, we can monitor mail or adjust religious practices if it affects operations, but it has to be done fairly and respectfully. The 14th Amendment is about due process and equal protection. This shows up when an inmate faces disciplinary action. They need to be given notice, a chance to respond, and a fair hearing before punishment. Also, inmates have the right to access the courts and legal help, whether that means talking to an attorney or using legal resources in the facility. At the end of the day, upholding inmate rights isn't just about following the law, it's about doing the job right. Respecting these rights builds trust, reduces conflict, and protects you and your coworkers from liability. It also reinforces the professionalism expected in this career.